Celebrity lawsuits, they can be messy and confusing too. And luckily, we have today a group of entertainment attorneys. They're going to help separate the fact from the fiction in the latest celebrity legal happenings.
And here with us to weigh in, we've got Lita Rosario. She's a graduate of Howard University Law School and principal of WYZ Girl Entertainment Consulting. Nicole Kober, another Howard University Law School graduate and a partner at Kober Johnson. And Jonathan Burns, he's a graduate of Georgetown University Law Center and an associate at Krooth and Altman, LLP. Welcome, everybody. Thanks so much for coming in.
Thank you.
Why don't we start with comedian Seth Macfarlane, who's being sued. Tell us why this is happening.
Yeah, so obviously we know the big 2012 release of Ted did great, about $549 million worldwide. So a company named Mangle Productions is actually suing Seth Macfarlane and Universal Pictures for copyright infringement. They're claiming that they came up with the character and he later used that portrayal of that character in his movie Ted.
Will it be difficult to prove infringement in this case?
Oh, sure. It still will be difficult to prove. There's a high standard. The standard is substantial similarity, which is a lot more than what a lay person would consider. But what the plaintiffs are claiming is that this character was out there and that he had a YouTube channel and that Seth Macfarlane knew about it. They're alleging that he, based on information and belief, actually knew about the character and used him. And in the complaint, they actually have color pictures of the two characters. Interestingly, they copyrighted the character itself in addition to the script for the web series. So it's going to be very interesting to see how this turns out.
And I'm wondering, Nicole, you know, why is this coming up now? I mean, hasn't Ted been out for years?
That's a great question. Well, the cynic in me would say because Ted 2 is coming out and 500 million plus whatever
absolutely.
2 is pretty good sum. But I think, as Rosario talked about, the access, this is going to be a hard case to prove. I love the case of George Harrison way back a short time ago, which is where they had to prove both access and some substantial similarity. Well, the former Beatle was found to infringe because his song My Sweet Lord was substantially similar to He's So Fine by the Chiffons. Well, here not only do you have a substantial similarity but access. There, that was an international hit. Here, a YouTube video. They have to make the argument that there was a connection, that it was so in the mainstream that you knew about a YouTube video. I asked my expert, my 17-year-old son, who's expert of all things internet, he had never heard of it. Had you heard of it? I hadn't heard of it until this lawsuit. So I think that that's going to be a hard burden to prove.
I'm wondering, Jonathan, if this will affect at all the release of this second movie.
I imagine there will be some type of settlement, some type of dismissal in advance of the release. I don't think it would postpone the release whatsoever because it's slated to come out in June of 2015. So that would be a lot of moving pieces that would have to move a different way to kind of stall that release.
So what you're saying is the people bringing the suit, really what they want is money out of this?
I think you bring a lawsuit for money every single time, so I don't think that's any different than any other case. So,
no surprise there.
I will say this, there was, I mean, while it was on YouTube, it was also on a number of different websites too. So it was on funnyordie.com, which is a very mainstream website. So I think that was also articulated in the complaint that it also appeared on Vimeo, on funnyordie.com, amongst other things. And they're also claiming 1.2 million views from the course of when it came out in June 2009 till when Ted came out in June of 2012. So while infringement's very difficult to prove, I mean, the claims that they're articulating in the complaint are somewhat persuasive.
All right, well, let's move on to another interesting case. TRACY Morgan is suing Walmart, and this is a month ago there was that fatal crash on the interstate. What's going on here, Lita?
Well, you know, typically when you have car accident cases, you have lawsuits. In this case, it's involving, you know, celebrities, obviously TRACY Morgan, and a couple of the other passengers in the limousine. They had just finished a show, and they were on their way, you know, back to their hotel, etc., when the crash took place. What's interesting is that they're alleging punitive damages against Walmart, and they're alleging that the driver, who lives, I guess, in Georgia, was basically commuting back and forth to work, which is not really uncommon for truck drivers, but they're claiming that he was out there for 20 hours without any rest, and that Walmart should have known there would be a great likelihood of a car crash or something to this effect. and the driver has actually been, you know, indicted. So we'll see what happens. They're claiming punitive damages against Walmart, which is kind of a high burden. You have to show that there was some intentional conduct or something near intentional conduct by Walmart. So it's a big one.
I just want to make a point that it's not just that he commuted to work from Georgia to Delaware, a 700-mile commute. That's egregious, and I would argue that that's what the plaintiff is going to say, that that wasn't while he was on duty, that was just to get to duty. So, you know, while he might have technically been in compliance with the hours that he was at work, but that commute was egregious. Additionally, I read the complaint. It said that also that there might have been a defect with the truck. The truck did not engage its, you know, high-powered brakes. They have auto sensors, so when a traffic is coming to a close, the brakes should have already engaged, and they didn't. So as an ancillary issue, I think that there may be a manufacturer defect issue as well.
I guess the point that you're making here is that how much Walmart has to do with how much the trucker works. I mean, sometimes these truckers sort of work on their own schedules, right? And they load up their own trucks and they make their own routes, and as long as they get the job done, you know, whether they get sleep or not is on them. How much does Walmart actually take responsibility for that, John?
Well, Walmart's the giant, and I think they're responsible for really closely monitoring those hours because, I mean, for incidents like this, you don't want, from PR and from a damages standpoint, you don't want any type of accident to occur. So you have to, they really monitor those hours very closely. So, I mean, to Nicole's point, it was highly unreasonable for them to allow this man to be on the road for that long.
And I'm glad that you brought up PR because they have to think about that. You've got a celebrity here that is loved by the public, a lot of empathy. How big of a hit could Walmart take from this?
Oh, and they've already come out and said they'll do whatever they can to right this wrong. So I think they're already somewhat willing to, whether it be give up money, whether it be do whatever they can to prevent this PR nightmare, because Tracy Morgan obviously is a well-known name. So that coupled with someone dying, I mean, it's horrible, and it's very horrible.
All right, we got more legal cases to talk about. Panelists, stay right where you are. We're coming right back in just a minute. Stick around.